Hello everyone, I'm Ratrika Bhaumek and I welcome you all to another episode of Courts Today on LiveLaw, where we update you about all the important legal developments that took place across the country today. We will begin with developments from the Supreme Court of India and then move on to High Courts and other subordinate courts. If you like our content, then it would mean a lot to us if you could please like and subscribe to our YouTube channel. Let's begin. In a recent development in the ongoing conflict between the centre and the judiciary over judicial appointments, the Union Law Minister Kiren Rijiju has said today that publishing the opinion of the Research and Analysis Wing, that is the RAW, and the Intelligence Bureau, that is the IB, on candidates recommended by the Collegium for judgeship is a serious concern. He added that making the secret or sensitive reports of the RAW and the IB public is a matter of grave concern which will be addressed in due time. The Law Minister made this remark while responding to a question concerning the Supreme Court Collegium's recent statements, putting on record the reasons to reject the objections raised by the central government to recommendations made regarding the appointments of judges in the high courts of our country. We have made a detailed video on this development, the link to which has been given in the description box below. Please do check it out. The Supreme Court of India today held that in determining the entitlement of a convict to premature release, the policy of the state government on the date of the conviction would be the determinative factor. This particular matter was heard by a bench comprising Chief Justice of India D.Y. Chandrachud, Justice P.S. Narasimha and Justice J.B. Pardiwala. The Supreme Court of India today passed restricted interim orders in a batch of interim applications seeking an interim stay on the order dated February 17th last year passed by the Tamil Nadu government on banning the use of purse nets for fishing. The bench of Justices A.S. Bopanna and Hima Kohli passed the order allowing the purse fishing beyond the territorial waters of Tamil Nadu but within the exclusive economic zone with certain laid down conditions. The Supreme Court of India today struck down the Assam Rural Health Regulatory Authority Act of 2004, which permitted diploma holders in medicine and rural healthcare to treat certain common diseases, perform minor procedures and prescribe certain drugs, upholding a 2014 Gujarat High Court judgment declaring the act to be unconstitutional in nature. A division bench of Justices B.R. Gawai and B.V. Nagaratna held, and I quote here, the Assam Act seeks to regulate such aspects of medical education that are within the exclusive domain of the Parliament and is liable to be set aside on the grounds that the state legislature lacks the necessary competence. The creation of special courts for the purpose of trying cases under the Bihar Prohibition and Excise Act of 2016 was a long distance away, the Supreme Court has observed. A division bench comprising Justices Sanjay Kishan Kaul and Abhay Oka was deliberating upon the issues of the grant of bail and pendency with respect to the offence of liquor consumption as well as the additional infrastructure being built as well as the manpower being deployed to handle the huge number of cases when it comes to detainees seeking bail in these excise matters. Observing that it was premature on the part of the High Court to quash a show cause notice issued under Section 130 of the Central Goods and Services Tax Act by invoking Article 226 jurisdiction, the Supreme Court recently set aside an order passed by the Punjab and Haryana High Court. The Supreme Court of India noted that there were allegations about evasion of tax and hence it was premature on the part of the High Court to opine anything as to whether there was evasion of the tax or not. The same was to be considered instead in an appropriate proceeding for which notice under Section 130 of the Act was issued. A bench of Justices M.R. Shah and C.T. Ravikumar gave this particular judgment, setting aside the order of the Punjab and Haryana High Court. In a plea seeking weeding out of harmful chemicals and pesticides being used in India, causing severe health hazards to farm workers and people living in the vicinity and the consumers, The Supreme Court of India has directed the central government to file an updated status report in respect of the regulatory measures taken by it in effecting a ban on hazardous pesticides. Considering the variance in the submissions made by the petitioner as well as the union government with respect to the banning of hazardous pesticides mentioned in this particular petition, a perplexed bench comprising the Chief Justice of India, D.Y. Chandrachud, and Justices V. Ramasubramaniam and J.B. Pardiwala has asked the Additional Solicitor General, Mr. Vikramjit Banerjee, to submit an updated status report in order to obtain some clarity with respect to this matter. The Karnataka High Court has said that if a wife is directed to pay maintenance to an able-bodied husband who does not suffer from any disability or infirmity, it would be promoting idleness. A single-judge bench of Justice M. Naga Prasanna made it clear that merely because Section 24 of the Hindu Marriage Act is gender-neutral for grant of maintenance, it would be promoting idleness, notwithstanding the fact that the husband has no handicap or impediment to earn. The Delhi High Court has sought the response of the central government on a plea seeking notification of separate vacancies for transgender persons in public appointments, including the teaching positions. Justice Pratibha M. Singh pleaded the central government's Ministry of Home Affairs as a party to the plea moved by a transgender person and granted 6 weeks' time for filing a reply. It was argued before the court that mere mention of transgender as a separate gender in the application form would not be sufficient compliance of the Transgender Persons Protection of Rights Act of 2019, as the persons would still be forced to apply in a vacancy which is either for male or female candidates or for vacancies where no gender is specifically mentioned. The Delhi High Court has quashed a first information report, that is an FIR, registered against a second-year law student who appeared before a district court as a proxy counsel for a lawyer and had sought an adjournment in a case. Observing that FIR should not be registered against law students for posing as lawyers before courts, the Delhi High Court has said that they should instead be counselled. Justice Anish Dayal said that a law intern is a student who is in the process of understanding the court practice and procedure, and therefore it is a duty of the institution to take adequate steps to facilitate their education and training and not simply punish them for these inadvertent acts. We have made a detailed video on this particular ruling as well, the link to which has been given in the description box below. Please do check it out. Thank you. Keep watching Courts Today on LiveLaw for more such updates. See you tomorrow.